Welcome to the video lecture on Chapter 6. So Chapter 6 is focused entirely on impeachment and credibility. So first things first, a prosecutor or defense attorney can present a witness to the jury, and the jury can choose to believe all of that witness's testimony, parts of that witness's testimony, or none of the testimony of that witness. In fact, it is not at all unusual for a jury to disbelieve all of a witness's given testimony. Another really important point to make here is that not all false testimony is a lie. It may just be that it is inaccurate or distorted or something else is going on. So not everyone who gives inaccurate testimony is lying, which is part of what enables impeachment to occur with most witnesses and to be effective against so many witnesses. So when we are talking about impeachment, this is not like impeaching a Supreme Court justice or the president. This means to damage or destroy a witness's credibility. And there are five common methods to impeach a witness. The first method is to contradict their testimony with other testimony. By demonstrating that the witness has bad character with respect to a trait of truthfulness, and by showing the witness has made prior inconsistent statements to their current testimony, by demonstrating that the witness is biased, or by showing that the witness has a failure or deficiency in the ability to perceive, remember, or narrate. So this sounds kind of weird, but like if someone wears glasses and they got up in the middle of the night and they didn't put their glasses on, that would be an effective track to impeach that witness with. Sorry, that was a little tiny bit disjointed. I had a kid running in, so I paused the video. But now for cross-examination, if you're crossing a witness and your primary goal is to impeach that witness, you can question that witness on a variety of topics that may seem unrelated to the issues of the case. Generally, cross-examination is only about the scope of the direct examination, but credibility is almost always considered relevant for cross-examination. So if you're trying to portray that this person has bad character for truthfulness, you may want to cross-examine and show evidence of conviction of certain crimes, question them about bad conduct that did not result in a conviction. For instance, cheating on their taxes, not filing their taxes, things like that, even if they've never been convicted. If you can demonstrate that they haven't filed their taxes in 3 years, that shows bad character for truthfulness. A reputation for untruthfulness, or you can have another witness come in and testify that this particular witness is untruthful. When we are dealing with crimes that can be admitted to impeach, these are felonies. You have to have the possibility of being punished for more than 1 year needs to be on the table, or it needs to be a crime of dishonesty, regardless of whether or not you were punished. So something like embezzlement or perjury are always going to be relevant for impeachment. Now, we always balance whether or not these convictions can come in under Federal Rule 403, but if the witness is also the criminal defendant, a different balancing test applies. If the witness is the criminal defendant, then the evidence is only admissible if the probative value outweighs the prejudicial effect to the defendant. So in other words, we cannot admit past convictions just to show this defendant is a bad guy, and because he's a bad guy, he did this crime, because prosecutor still has to meet the corpus delicti in the prima facie case for the conviction to stand. And this differs from the general 403 because we have the substantial. The prejudicial value can be slight and still be excluded here. Now, crimes involving dishonesty or false statement, these crimes are going to generally be perjury, subornation of perjury. So this is getting someone else to perjure themselves, false statements, criminal fraud, or embezzlement. Crimes of false pretenses. If we think about this is like committing theft through trick or deceit, if we think back to our criminal law class. And then if you can demonstrate that the elements of the crime include falsification, deceit, or untruthfulness, then those can also be admitted here. You can use misconduct that does not result in conviction. There are a bunch of other rules, but just know that that is possible. Opinion and reputation evidence are also admissible here. So if you're calling a character witness, we generally need someone who has sufficient personal knowledge and is in the position to render an opinion or testify on the reputation. We call this person a character witness, and their testimony is usually limited to the opinion or reputation of the first witness's truthfulness, honesty, or integrity is poor. Reputation evidence is hearsay, but it's admissible under the hearsay rule, and this is where the character witness says, well, this person is well known in my community for untruthfulness. They lie, they swapped EBT cards with somebody, they took and forged a check to pay for something at the local store, things like that. When we're qualifying someone as a character witness, we need to demonstrate that they have had close contact with that person. And the character witness is just talking about general things. They're not going to give specific instances of conduct. Now, impeachment by contradiction is the act of saying the opposite of a statement or specifically denying the statement. In its simplest form, this is the act of the cross-examiner, the lawyer, asking the witness to deny the facts previously stated. So this would be something like, you claimed to have been present here, but that's not true, is it? And as you can imagine, this is not generally very successful. And it can get the lawyer in trouble for being argumentative with the witness. Now, prior inconsistent statements is a frequently used method of impeachment. This is looking at past statements and seeing how they differ from the current testimony. The inconsistent earlier statement could have been made at any point during the trial, or they can be something that is said during the trial. And in hopes that a witness might make an inconsistent statement is one of the reasons that a lawyer might pursue an extensive cross-examination to see if they can trip this witness up into making an inconsistent statement. Any inconsistent statement can be used to demonstrate a weakness of credibility, regardless of why or how the inconsistent statement came to exist. When an inconsistent statement is used for impeachment, the relevance does not depend on the actual inconsistency to be true. It just matters that there was an inconsistent statement, not whether or not the statement was actually true. Generally, there is no special foundation, or you don't have to go through extra steps to get the inconsistent statement into evidence. The only requirement is that when you are going to impeach with a prior inconsistent statement, the witness needs to be given an opportunity to explain or deny. So the jury, they might have made an inconsistent statement, and during this chance, the jury might find that the reason they made this inconsistent statement is perfectly acceptable and still take that witness's testimony as a whole as complete. When we're working with a pretrial statement, we're looking generally at the defendant's statements are independently admissible as opposing party statements, and any of these inconsistent statements need to meet constitutional and procedural requirements. So you cannot use something that violated the defendant's rights. Another effective impeachment tactic is bias. So this would be that the defendant is a close relative or an employee or something along those lines where they have a reason to hope to support one side over the other. When we are looking at witness capacity, we're looking at the ability to perceive, the ability to remember, the ability to narrate, sincerity, eyesight, hearing and sense of smell. If there is a deficiency of any one of those specific items, the witness can be impeached for it. We cannot impeach somebody because they don't have a religious belief. That is unacceptable under the federal rules of evidence. Prior consistent statements are not admissible, so you cannot support a witness by saying, oh look, all the times they said the exact same thing, so therefore this must be true. You cannot do that. Those are generally inadmissible. Now, one other thing to note is you can impeach your own witness if under the new rules. If you need to, you can impeach any witness, even your own. Witnesses don't always support the side that they're called for. They are there to say what they have to say, and that doesn't always match up perfectly with each side. Now, when someone is called to be a witness, when they get that subpoena, they need to obey the order whether or not, but they have to answer everything truthfully unless it will incriminate themselves. Witnesses have a privilege against self-incrimination if the answer would show that they tend to show they are guilty of a crime or would subject the witness to the possibility of a prosecution and conviction. The witness may refuse to answer. A witness can also refuse if the answer would just connect them or identify evidence that could link the witness to a crime. So witnesses do not have to incriminate themselves even under the power of a subpoena. The privilege against self-incrimination applies to official hearings or any other civil trials. And this is why courts look so closely when confessions. Now, the witness can claim privilege against self-incrimination. The trial judge can explore that further and ultimately decide if this would actually incriminate them. Sometimes people don't want to answer things that are embarrassing or make them look bad, but that does not necessarily mean that it would incriminate them. So if a judge rules that the answer does not incriminate a witness and they refuse, then they can be held in contempt of court. And judges will look at the setting of the testimony, what other testimony exists, and the likelihood of possible prosecution as they're making these decisions. If the witness is connected to a crime or linked to a crime, then the judge should rule in favor of the privilege. All right, I'm going to pause this video.